about 30 seconds. We're just going to give everyone a chance to get into the room. So without further ado, Cecilia Chen, my good friend, how are you doing?
Good. Thank you for having me.
Yeah,
Hi,
I look
everyone.
forward to
Thank
it.
you.
So, yeah,
Yeah.
sorry, you're welcome. I'm going to put my phone on mute and I'm going to sit back and enjoy this. So take it away, Cecilia. Thank you.
Okay. Thanks. Hi, everyone. Thank you for joining us today. My name again is Cecilia Chen. I'm a dental attorney. I specialize in representing dentists in purchase and sale of dental practices, leases and contracts, employment manuals, and partnerships. I'm licensed in California and Virginia, and I practice in California. So most of what I'm going to be discussing will be based on California law. I also work with clients in other states where I associate with local councils. But again, what most of what I'm going to cover today is going to be based on California law. I've been practicing since 2004 and have specialized, have been focusing in the dental niche since 2011. So close to 90% of my clients are dentists, and I feel very honored to serve this industry. Um, so today, what I'm going to do is I'm going to cover the topic of associate agreement from both perspective, from the perspective of both practice owner, and then also from the perspective of an associate, and all the issues that are important and relevant for you guys to understand and consider when either drafting or having somebody sign one of these agreements. So associate agreement, first and foremost, associate agreements are important to have in writing, not just to protect the practice owner, but also to avoid potential misunderstandings and disputes that can be easily resolved by looking at the agreement. Without anything in writing, it comes down to, well, that's not what I said, that's not what I understood. And then a little bit of misunderstanding can all of a sudden turn into a huge disagreement. And the next thing you know, we are, in litigation or filing a complaint in labor board. With the labor board. So who has the time for that? So just have an agreement in writing, memorialize what both people understand, and it protects really both parties. So, for instance, how is the associate going to be compensated? Is it going to be percentage of production, collection, or minimum daily rate? If production, will discounts and refunds be taken into account when calculating the production amount? What about supplies and Laughies? If minimum daily rate, will there also be minimum hours worked per day, right? So these are things that need to be covered in writing. And now in a post-COVID era, how would the associate be compensated or not be compensated if they get sick, or being required to quarantine because the office has to close again? And what is your responsibility as an employer under the Family First Coronavirus Response Act? Has your employee manual been updated to address this and can be referenced in your associate agreements? So if you don't have an associate agreement in writing, get one drawn up ASAP, because again, it really is important to have those issues memorialized in writing. And if you have an associate agreement already for your associate, get in touch with your attorney to get it updated to include the provisions that are necessary to either be compliant or exempt from the Family First Coronavirus Response Act. These provisions are important to be addressed, if you're if in your employee manual, and also your associate agreement, to avoid misunderstanding and disputes. Next slide. We all know that, I'm going to talk about restrictive covenants. We all know that non-compete covenants in California are not enforceable between the employer and employee, meaning that you cannot tell an associate that he or she cannot work with, cannot work within a certain miles of your office for a specific period of time after they leave your office. That restricts a person's ability to earn a living, and California doesn't allow that. And there are exceptions, of course, which we will discuss later. But other covenants that are designed to protect your practice rather than limit an associate's ability to earn a living are enforceable. So courts do protect businesses from unfair competition, but only if you have it in writing. Even without non-compete covenants, you can certainly have covenants in associate agreements to restrict associates' ability to solicit the patients, staff, and referral sources after they leave your office, after they stop working at your office. And you can enforce those covenants by getting an injunctive relief from courts. And more specifically, injunctive relief is a term used in contracts to describe that one of the parties can ask the court to stop the other party from doing something that violates the contract. So a practice owner can get an injunction to stop the associate from creating additional damage in contacting your patients, staff, and referral sources until the case can be heard. So, oftentimes, being able to put a stop to those actions are more important and helpful than figuring out the monetary damages, which can take a significant amount of time to figure out in courts. So how will your associate be classified, a W-2 employee or a 1099 independent contractor, right? From an employer's perspective, paying an associate as a 1099 independent contractor will save you from having to pay unemployment insurance, workman's comp, and payroll taxes. But misclassifying your associate can land you in hot water in the event of an audit from EDD. I'm sure many of us have heard the Dynamax case from the California Supreme Court in 2018 that made the test of independent contractor much, much harder to meet. So in that case, the court held that the presumption is that most workers are employees and should be classified as such. So, and the burden of proof for classifying individuals as independent contractor belongs to the hiring entity. So this test under the Dynamax case is called an ABC test. So what does this ABC test cover? It means that every prong of that test, A, B, and C, all have to be met for a worker to qualify as an independent contractor. So the A prong of the test, in theory, is pretty easy to meet, that the worker is free from the control and direction of the hirer in connection with the performance of the work. So most of the time, you're not going to be looking over your associate's shoulder when they're treating your patients. So that's pretty easy to meet, because associate pretty much will have the ability to treat the patients on their own, have the ability to control their work. Now B gets a little bit tricky. It says that the worker performs work that's outside the usual course of the hiring entity's business. So if you're a dental practice and your business is treating patients and provide dental treatments to the patients, and your associate is also providing dental treatments to the patients, then they are performing work that's not outside the usual course of your business, correct? So that will make it pretty hard for the B to meet for most associate relationships for dental offices. C, that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So C, again, that is pretty simple to meet for most practices. The B one is more problematic. So what does that mean? Does that mean no associate can be classified as an independent contractor because the B prong cannot be satisfied under the Dynamax case? No, not necessarily. So last year in 2019, the California legislature passed an assembly bill called AB5 that allows businesses to apply for exemption. So several businesses tried to apply, like Uber and Postmates, I think, apply for the exemption, but it wasn't successful. But the bill provides for an exemption for certain professions, which actually includes the dental profession, which means that while the ABC test under the Dynamax case may not be applicable, but the test under the Borrello court case still applies when determining whether your associate is an employee or independent contractor. So what does that mean? The Borrello test, the test under the Borrello case, is referred to as a multi-factor test because it requires consideration of all potentially relevant facts, meaning not a single factor controls the determination. So courts have emphasized different factors in the multi-factor test depending on the circumstances. So for example, whether worker supplies the instruments, tools, the place for doing the work. So in most cases, the owner supplies the instruments and the dental equipment for the associate to be doing work, right? Whether the service provider requires a special skill, absolutely. For every dental associate, that requires a special skill to treat the patients. Now, the length of time for which the services are to be performed. So that one, so under the Borrello test, I'm only listing about three factors here, but under the Borrello test, there are actually about 13 different factors that you need to be concerned about when determining whether your associate should be classified as an employee or an independent contractor. And so I mentioned only three because those are, to me, I think these are the three most relevant for a dental practice. Now, the length of time, that is going to, in my opinion, the most relevant factor in your case. Are you going to, is the associate, is it temporary working for you? Is the associate only going to be working for you 2 to 3 months? Or is it going to be a long-term working relationship? Or has your associate already been working for your office for the last 5 to 10 years, right? And you're still classifying that associate as an independent contractor. That can be very, very problematic. And, you know, specialists, if the specialist is only coming to your office about 2 to 3 times a month, right? And that should be okay because that technically, even under the Dynamax case, they're not necessarily providing work that's what you ordinarily provide. Because if you are a general practice, you don't ordinarily provide ortho work, right? Or perio. So if a specialist comes in and do work that's outside of what you normally provide to your patients, so in theory, a specialist can fit under the B prong of the Dynamax case. But if this specialist is coming into your office on a regular basis, 3 days a week, seeing all of your patients, and you are advertising your practice as a multi-specialty practice, that the ortho work or the perio work or the endo work is what is part of the service that your office offers, then that gets a little bit more tricky in terms of whether you can classify that specialist as independent contractor for your office. So, every case, every working relationship is going to be different, uh, and and so it's important for you to really understand the different factors that's applicable in your particular case. And you should definitely check with your employment attorney before determining the correct classification. A wrong classification can result in significant fines and retroactive pays for the associate. And that can be a pretty large unexpected expense for your practice that you will want to avoid. Now, consideration from associate perspective. Now, as an associate, it's important for you to understand what's in the written associate agreement before you sign it. Oftentimes, the employer requires you to uh, indemnify the practice for any of your wrongdoing. But there is no reciprocal indemnification from the practice to you for their potential wrongdoing, right? So that wouldn't be fair. I've seen associate agreements that require the associate to appoint the practice as a power of attorney or sign over their rights to the practice for any billing matters, and that the associate has no ability to review any billing records. Now, that can potentially be problematic if there are any misbilling or overbilling issues, or worse, fraud. And it will be connected to your MPI and your ability to get credentialed with that insurance company in the future when you are no longer the associate for that practice. So once you leave the practice, should they still be able to use your name and pictures on their website and promotional materials, when you're trying to establish a new practice elsewhere? And how are you being compensated? What I mentioned earlier, are you being compensated based on percentage of production, percentage of collection, and how is that factored in? Are there discounts, lab fees, materials, are they going to be factored in to the calculation of production and collections? Let's see. Okay. And more importantly, what are your obligations under the restrictive covenants that we had talked about earlier? Are they overly broad and vague that makes it difficult for you to build a new practice elsewhere? When the term solicitation is used, what does that mean exactly? Does it mean that, you are calling them one by one, or are you allowed to send general mailings to that particular zip code that where most of the patients of the practice you were an associate at happen to draw most of the patients from, right? So that term solicitation, when that term solicitation is used, you need to understand what that means and how that term is defined in your contract. Non-compete covenants. We learned earlier, what I mentioned earlier, non-compete covenants are not enforceable in California between an employer and employee, but there are exceptions. If you're owner of the business, and when you leave, you sell back your ownership interest in the business, the non-compete covenant is enforceable when there is a transfer of goodwill between a buyer and seller. So I have seen that some practices are offering their associate a very small percentage of ownership interests for that very reason, so that the non-compete covenants can be enforceable. And they made the non-compete applicable to all of the offices the associate has worked at for, especially if the practice owns multiple offices. So if the non-compete is 10 miles and the associate has worked in all 3 offices for the owner, that 10-mile restriction will apply to each of those 3 offices. Or I've seen contracts where if the, if it's a corporate dentistry practice and they have multiple offices, they have like 10 offices within that particular county. So if they say 10 miles within all of the offices that they own within that county, that kind of restricts your ability to practice entirely in that county after you leave, right? So you need to understand what your obligations are, under these agreements when you sign these agreements, and is it worth it to take on a small percentage of the ownership interest? So, and what are the liabilities that might come with owning 1 or 5% of the practice, right? And what are your profit sharing rights? And how will the value of your ownership interest be defined when you want to sell it back to the practice when you leave in the future? So these are all very important factors to consider and understand with the guidance of an experienced attorney who can read and understand these ridiculous legal language and it makes sense of it, because you need to not be negatively impacted and restricted when you're ready to purchase or start your own practice in the future. It needs to be fair, for both sides. It needs to be fair in a way that protects the practice owner, but also fair in a way to the associate, so that they're not, so an associate still has the ability to earn a living after they leave the practice. So, most associate agreements will contain provisions about protecting the practice confidential information. Well, how is that confidential information defined, right? Are there exceptions for information that you already know, already out there in the public? And, the ownership of patient files, of course, belong to the practice. But what about the patients that you brought to the practice, like your family and close friends? What about patients that you went out and brought in through speaking and marketing events, or specifically referred to you by your friends and your colleagues, right? So, if you are the only dentist working at the office and the practice owner is never in the office and the patients only know you, you're the only one treating and producing for the office. Should you get some kind of reward or discount when it's time to negotiate a buying of that particular practice, right? Are you restricted from working at other offices if you're not working full time at the practice? So these are things that really should be addressed in your employment agreement, that protects you a little bit. Does your contract require workplace inventions, right? What does that mean? Does your contract require you to assign your interest in any inventions that you come up with as a result of working for the dental practice? I've seen many contracts that require any inventions made by the associate to belong to the practice, and that the associate is required to assign all rights associated with those inventions to the practice. But we need to understand, how are those inventions defined? And what if you come up with an invention on your own time without using any equipment, supplies, or facilities of the practice. And if you agree with the practice that, okay, so I did come up with the invention when I was working in your office, and it's related to this particular, procedure that I worked on for that particular patient, or the usage of that equipment in your office, and you're okay with assigning the invention that you came up with, or the design or improvement. But and you'll be required to sign many patent documents, okay? And so will you need assistance of a trademark and patent attorney to review those documents before you sign them? And would the practice cover those attorney's fees for you, right? So, and what about the time involved to assist the practice in those patent filing documents? Because that can be extremely time consuming. And will you be compensated for your time? And what should your compensation be? So, there are a lot of considerations when drafting and negotiating an associate agreement from both sides. And it's important to make sure that, your interests, whether you are an owner or whether you're an associate, either that you are protected and that it's somewhat fair from the perspective of both sides, regardless of which side you're on. And not just during the working relationship period, but how it might impact both sides after the relationship is terminated. So that's about all I have for this particular topic, and I'll be happy to address any questions you guys might have.
Yes, Cecilia, fantastic. So there's a few questions in the Q&A, and if you guys have questions or comments, please put them in there now, and Cecilia is going to go ahead and answer those. There's a few in there, and you can use the anonymous feature if you want to put your questions in anonymously. Cecilia, and as a practice broker, I need to ask you, first I'll state that, when I go to sell a practice, I ask the selling doctor, do you have an associate there? And they say, yes, we do have an associate. And, it's a little precarious. And I say, well, tell me a little bit about the associate. And if the associate is, the hottest thing out of USC Dental School, and he or she can sell ice cubes to Eskimos and the patients love that person, then it's somewhat problematic, and it could discount the practice because, as you stated, there is no covenant not to compete on an associate within the practice. So this 1% ownership idea, seems to make sense. But then from the associate side, when you talked about, if it's a corporate office that has multiple locations, that's pretty scary, that 1% ownership. And if you put all those 10 or 15 mile radiuses on a map, it could really put a person out of an entire city. They could be out of Orange County or Los Angeles or San Diego. So yeah, it kind of cuts both ways. And I like your presentation because it's kind of protecting the interest of both sides, during this process. So yeah, there's a couple questions here in the queue we'll get to and see what we have. The first one, Cecilia, is, in California, if an employee requests while she was furloughed to use all the sick hours she has accrued before April 1st, then she eventually gets laid off before April 1st, is the employer obligated to pay the sick pay even though the employee is not scheduled to work at the time?
So the sick pay, the 3 days that's required by, so it depends on whether how is it addressed in your employee manual, right? Do you have the 3 days? Do you offer the 3 days at the beginning of each calendar year, or is it accrued over the year? And does your office have more than 50 employees? So if your office have less than 50 employees, then the Family First Coronavirus Response Act is not going to be applicable, requiring you to pay additional the 80-hour sick time for your staff if you have less than 50 employees. So if that's out of the question, and then it comes down to how are the 3 sick days addressed in your employee manual. Is it given at the beginning of the year, or is it accrued over the year? And if it's accrued over the year, and if that staff hasn't accrued all of the three days from working in your office, then you shouldn't have to pay for the sick leave. But if you provide in your employee manual that the 3 days, three sick days is given at the beginning of the year, then that has already been accrued for the staff, and that they can use any time they want.
It definitely, and that was confusing for me when that first came out, because I was unsure with my employees if I had to give them the accrual PTO plus the 3 sick days, and then I found out that if I'm giving them accrued PTO, that those 3 sick days can be factored into there. So what you're saying is if you offer those 3 days in and of themselves, then yeah, those are theirs, they can cash those out. But if you have some sort of accrual method, this is the time that I hope, if most of you are not in the office working, take a look at your employee manual. You need to make sure that it's up to date. You have all of the policies that you have in your manual is up to date, that's compliant to the law to date. Understand that employment law changes every year, and as new cases come out and new rules are codified by the legislature. And so, and how those sick leave are addressed in your employee manual, and how it's going to be used by your staff, and whether or not your practice needs to be compliant or exempt from the Family First Coronavirus Response Act, that all needs to be addressed in your employee manual. And to say, as far as employee manuals, when you disseminate an employee manual that you have, do you offer intermittent updates? Like every 6 months, you'll say, here's an update to your employee manual to add? Because I can see if I have an employee manual that's 10 years old, I can go to an attorney and I can say, can you review this? And it might cost me some money to have you sit and read that. Or do you have a brand new employee manual that you would give me, and we can just throw the old ones on the bonfire and get rid of them?
So what I've been doing for my clients is I tell them to review it with me every year, or because there might be some quick updates we can just incorporate into your existing manual, or we can just do a simple amendment and give it to your staff and have them acknowledge those updates. So it can be a lot simpler than doing a whole new one. Now, if your employee manual is 10, 15 years old, it might be easier probably to do a brand new one than updating every single section, because pretty much everything is probably outdated at this point.
And a related question, Cecilia, I apologize if this is a bad question for you, but we had an employment attorney on yesterday, and he talked about the training for the new PPE procedures, and having employees acknowledge they've received that training to fight any liability. Do you think that there's any update to the employee manual that's going to cover some of this new PPE and this new environment that we go into?
Absolutely. That the employee manual should have those updates, and have the staff to acknowledge the training that they have received, that they are going to follow those protocols, and and there should also be the supplemental office procedures that I had mentioned on your webinar 2 weeks ago, about the different office procedures that the staff needs to now follow, specifically with respect to coronavirus. And the acknowledgement and the consent and waiver forms, that should all be a part of your employee manual and forms.
Perfect. Yeah, and I appreciate that. And I would think, do you have a form available? I like to think of you as the brushing and flossing attorney, and less of the it needs an implant attorney. And when I say that, I mean that more proactive to prevent future problems with the services you provide, versus staying in court and fighting it. If they contact you, do you provide any updates to the employee manual as far as COVID training and things that the employees can sign?
Right. Absolutely. Yeah.
Perfect. And then some asked in the chat for Cecilia's contact information. You should see it there on your screen. Her email address, I believe, is similar to her domain name. So say if you could give your email address in the chat, sometimes it's easier for people to email you
can
than
people
to.
see my screen? My screen right now has all of my contact
Yeah.
information.
Okay, there's no email address there, but they can go to the domain and there's a chat box.
Oh, right. So. Sorry. It's
okay.
C Chan. Hang on. Let me see if I can do this. Oh, whew.
That's okay. You can read it out. I mean, it'd probably take a little bit of time to put it up there.
It's C-Chan at practiceatty.com.
Perfect.
So
see, the next question.
It's CCHEN at practiceatty.com.
Perfect. And for the people listening on the podcast, I apologize to those who are live. Phone number Cecilia Chen is 855-850-4111. Cecilia, the next question is, as an employee dentist, I have a valid enforceable contract in place with no force majeure clause. Is it then legal for my employer dentist to unilaterally furlough me due to the COVID-19 situation and advise me to seek unemployment?
I believe so. I believe so. But because, California is an at-will state. So, and especially what your contract might provide, your contract might provide that there needs to be a certain notice period for both sides. Is there a 2-week notice, 4-week notice? So, and does it apply to both sides? So you need to check your contract to see if there are any notice requirements, and if the practice didn't, provide the notice, then technically they might be in breach of the contract. But without, and aside from the issue of the notice, does the practice have the right to furlough an employee due to the COVID-19 situation? They do. And especially, California is an at-will state, unless your contract specifically says that you're not an at-will employee. That the presumption is that you are an at-will employee, and that at any time you can be terminated or furloughed, unless there are notice requirements.
Perfect. Yeah. It didn't say what state that is, and they can update that if they want. The next question, Cecilia, is: would you recommend taking on an associate without any contract at all?
No, that's the majority of my of the webinar is talking about the importance of having everything in writing, and it really is important for so many different reasons. Basic things like how is the associate going to be compensated, and is a percentage, what is that percentage? If you guys agree to a percentage of 28%, well, 28% of what? 28% of production, or 28% of collection? And if it's production, is it going to be adjusted by taking into account of Laughy, supplies? So there are so many things that you really should have addressed in writing, for no reason other than avoid misunderstanding, avoid disputes that can potentially end up in court and labor boards, which you don't want, right? Who wants to deal with that? But if you have it in writing, you can simply say, hey, look, this is what we had agreed to in our contract, and this is what you have signed, this is what we have signed, and this is, and so simple misunderstanding won't get snowballed into a huge case that can cost you thousands, tens of thousands of legal fees to litigate in court. And of course, a written contract will provide the protection of the covenants I had mentioned. Now, Jonathan, you had mentioned earlier, it gets tricky when a practice has an associate, when non-compete is not enforceable in California. But covenants such as non-solicitation of patients, non-solicitation of staff, non-solicitation, referral sources, those covenants are enforceable. And they are important, so that even if the practice owner sells to a third party and the associate is not the buyer, at least the buyer should be able to feel a basic level of protection that the associate, when that associate leaves, they're not going to have the ability, to go after the patients and staff and the referral sources. And that should, give the both sides a little bit of comfort level in proceeding with the transaction if the associate is not the buyer.
And to say, in the context of that question, would you suggest that an associate enters into an associate agreement without a contract? Should they ask for a contract if it's not being offered?
From an associate perspective, I do personally think that a written agreement can, if it's drafted correctly, it should be able to protect both sides. But by and large, it actually protects the practice owner more than the associate. So from an associate standpoint, if you don't have a written agreement, I wouldn't care, because then you're not obligated to for a lot of things, right? You didn't agree in writing to not solicit patients or staff or referral sources, and you didn't agree in writing that you'll give a certain period of notice. So from an associate standpoint, probably you're better off to not have a written agreement. But from a practice owner's perspective, it really is more important to have an agreement in writing.
Yeah, it's interesting. Your answer on the associates having the agreement or not having it made it even more compelling for any employing doctors to make sure they have an associate agreement in place, saying that
Right.
There's no restrictive covenants and things. And then, to be fair, you do help employing doctors draft associate agreements for their associates or future associates, and you also review associate agreements for people going into an employment situation. Is that correct?
Yes, absolutely.
Perfect. So the next question is from Dr. Q. Cecilia, they said she was clarifying regarding independent contractor versus employee status. I was told there was an exception made earlier this year that said dentists were okay to be classified as independent contractors. Is that not true for an associate working as a GP?
No, that's what I mentioned earlier, that the Assembly Bill, the AB Bill 5, that makes an exemption for dentists, but the Referral test still applies. So the Referral test is the multi-factor, that there are about 13 different factors that come into play that a court will consider if, based on all these different factors, whether you are you should be classified as an independent contractor or an associate. It's not that the Assembly Bill doesn't give a blanket exemption for dentists. So everybody needs to understand that, because I'm hearing from a lot of people that think that bill came out provides a blanket exemption for dentists. Not true at all. It just kind of makes an exception for the dentist to have to meet that ABC test under the Dynamax case, because that's impossible to meet for dental practices. But you still have to meet the criteria under the Referral test that talks about, the different factors, such as, how long will you be working at the practice? Do you have control over the work that you perform? Do you use your own instrument and supplies, etc.? So that list is, let's see, that list is, like I said, it's a 13 factors that you need to take into consideration. And I can
And
send that that list of 13 factors to anybody who wants to know what they are. I'm happy to send it to you guys, and just email me. But you know, again, I just want to reiterate that the Assembly bill does not provide a blanket exception for dentists, contrary
perfect, Cecilia,
to
to what was said. And I apologize. Just in the context, this next question is pretty similar to kind of the other side of the coin. Anonymous says, I'm an associate dentist. I feel like I've been misclassified as an independent contractor. What should I do and what are my rights? So in the same context of answering the first question, maybe you can cover this one.
file a complaint with the labor board.
Do you think that they should approach their employing doctor with some compelling information before they do that? Or is there another way to?
They could, yeah. I mean, you can certainly ask the employer and say, hey, you know, I believe that I'm being misclassified, and here are, you know, my reasons. And, you know, but a lot of times, you also have to be prepared that, you know, that your compensation will go down, right? Because that's what I've seen when the associate is, the classifications change from independent contractor to a W-2, the compensation also goes down, because the practice needs to take into account of the additional expenses they now have to pay, you know, as a result of you being an employee. So that will just require discussion and negotiation, and hopefully to come to an agreement that both sides are happy with.
Perfect. And perhaps this person can contact you directly to get some more clarity on their specific situation.
Right. But,
Sorry, I interrupted you. You were said, go ahead, please. Sorry.
You know, but you know, practice owners need to understand that there is a huge risk in misclassifying their associate, because some associate might just file a complaint with the labor board, and next thing you know, you are in a deep, you know, audit with EDD, and the amount of fines and penalties that and the retroactive pays that might be associated with the misclassification, it's really not worth it.
Perfect. Cecilia, the next question we have for you from Anonymous is, how do you negotiate a per diem now? A lot of corporates are doing half the rate they originally agreed to, or no per diem at all. And Cecilia, I would add, as we enter into this atmosphere of less efficient dentistry with social distancing and PEPs and not seeing as many patients per day, could possibly COVID-19 have killed the per diem? Is that a thing of the past?
That's possible. That's very possible. And it's going to be tricky, because if you know, especially if the compensation, aside from the per diem, what if the compensation is based on the percentage of, you know, production, and if you aren't able to produce as much as before because you are required to see less patients, you know, are you able to perhaps negotiate a higher percentage rate? I don't know. That's going to be tricky.
Definitely. So some unknowns coming up.
Right.
Cecilia, Anonymous is asking, my employer hasn't paid me for hours worked, bonus done prior to shelter in place. Complaining he or she doesn't have the money to pay. Is it legal? So this person has accrued benefits.
That's absolutely not legal. I mean, if you had done work that you should be compensated for and you're not being compensated, that is a huge problem. Practice owners, please don't do that. I don't. Even if you have no money in your bank account, you cannot pay your associate when they have treated your patients and have earned the compensation, because that's a ripe, you know, case for a labor board dispute. And you are not going to win. I mean, it's not a defense to say, I'm sorry, I'm not able to pay just because I don't have money in my account. You know, borrow
So
money
Cecilia,
or transfer money from whatever source you cannot not pay your staff and associate for work that they have completed.
and that seems to be the labor board favoring the employee, especially in this situation, quite a bit. And in the hierarchy of payments, I guess you would advise paying the associates or the employees before you even pay your vendors or your rent or your landlord. So I mean, it's definitely important because you don't stand a chance. Do you have a template of do you have a template of an associate contractor asking? I'm sure you have one that you provide, but I don't know that you just provide a template of that.
No, that's not I don't have a template because every case is different, and every compensation structure, every working relationship is different. So I customize it, you know, based on that particular employee relationship.
And I know you've put a lot of time, energy, and effort into that contract to make sure that it is very solid. So yeah, anyone that needs a contract, I would contact Cecilia, and then she can customize that for you and get that to you. The question, Cecilia, is I thought that sick hours are paid out only when employees are scheduled to work and are sick before April 1st. So why need to pay any accrued sick pay if the employee asked before April 1st and is not scheduled to work?
So that would depend on what your employee manual says.
So if the manual says that we gave those 3 days of sick pay to the employee and they happen to not use them, by right, those are still yours. So
they can use them. So if your employee manual says that the three sick days are given at the beginning of the year on January 1st, 2020, then it doesn't matter. You know, I'm not sure what you mean by employee are not scheduled to work before April 1st, because that date doesn't really matter. But you know, again, the difference is whether it's given at the beginning of the year or if it's accrued over the year, and that's the fundamental, you know, difference, and that should be addressed in your employee manual.
yeah, and I think this context is that if they were given to this person, or they had accrued and they had actually earned, or they have those sick days in their possession, and for some reason the employment was terminated at or before April 1st or any time, you know, those belong to the employee. Yeah, well, not terminated, but they left employment. Let's just say they separated employment for any reason. Okay. So the question is, these are sick days to be used when they're sick, but if I gave them to them, I have to pay those out as final benefits. Is that correct?
Again, no, not necessarily, but that depends on how it's addressed in the employee manual. Sometimes it can say, you know, either you use it or you lose it, or if it's stated in the employee manual that it needs to be paid out if it's not used, or it can be carried over to next year. How it just depends on how it's addressed in the employee manual.
So I would think that this downtime is a great opportunity for people to examine their employee manuals, possibly call and ask you questions, or share that employee manual with you, so you can address any items that might be missing in there. Because it keeps coming up over and over again that the employee manual is very, very important. That it protects the doctor and also helps the employee understand, you know, what their privileges are and what's going on.
Exactly.
Cecilia, Anonymous is asking, I was placed on furlough in April and filed for unemployment. I have a valid contract with base salary, but can my employer dentist ask me to come back to work now with my state opening up and ask me to still file for unemployment since he is not sure that he can pay me my salary due to lack of business or production?
No, they can't do that. That's fraud. They can't tell you to come back and work and not pay you, and to tell you to file unemployment. That's not okay. And please don't go along with it, because then you are a participant to the fraud. You can.
No, it
You can
makes
use the
sense. And
license.
yeah, and there's some interesting, I don't say moral quandaries coming up, but it's stated everywhere that for some people the unemployment is more than they work while they're working, and what's the incentive to go back to work? So there are going to be a lot of issues created with that, and then as well as employing doctors. Wow, you're getting unemployment, you're making good money, but I need to onboard you again to get this business back up and running. So, that's the quandary of when do I offer this employment back? When do I bring them back in? And then convincing employees that, if the state of whatever state you're residing in, if they say, let's open these practices up on June 1st, Super Bowl team doesn't step on the field without a huddle and score touchdowns and win the game. So that dental team is going to need to huddle and come together before that June 1st opening date. And that's kind of a quandary too of wait, we can't open until June 1st, but I'm going to come in and start working before that. So there's a lot of moving parts here that I would suggest if you have specific questions, you reach out to someone like Cecilia and she can help you address and answer those. Cecilia, Anonymous is asking, can a hygienist be classified as an independent contractor? I see you typing. Do you want me to give you a second to type?
Hang on, sorry. I was trying to type my email address in here and I did it wrong.
You're at .c. No, I'm kidding. So sorry, let me read the question to you again. I apologize. You were typing and I wanted to catch you off guard.
No, it's okay. So can a hygienist be classified as an independent contractor? It depends. How often does your hygienist come in and work for you? Once or twice a month, or 3 or 4 days a week, right? There's a huge difference between the two. And so for a dental hygienist, I personally believe that the Dynamax case, the ABC test will apply. So, does the hygienist work fall outside of what you typically provide for your customer, for your patients? And if it's part of the integral services that a dental practice provides, then I don't believe a hygienist can be classified as an independent contractor. But I could be wrong, but that's my interpretation of the case laws.
Perfect. So we are about an hour into the call, so we're going to go, if you're available, Cecilia, to finish up all this Q&A. We've got about 7 more questions here in the queue. So if you guys want to bear with us, we still have the same number of people on the call. So let's fire through these 7 questions and take your time answering. Sure. For the people listening, if you need to vacate, exit the call, take down Cecilia's contact information and feel free to reach out to her. Anonymous stated, I'm also in that situation of not being paid my last paycheck, 3 exclamation marks. Should we contact an attorney or call the labor board? Question mark.
So the last 3 paychecks for work that you have done? Or
their final paycheck. They're saying their final, no, I said 3 exclamation marks, not 3 checks, but they haven't been paid for their final paycheck is what they're saying for the hours that they worked in crew.
So yeah, for the hours that they have worked, that's not okay. So first, contact the owner and ask them. And if they say that, if they keep giving the excuse that they don't have the money to pay, that's not good enough. That's absolutely not good enough. And that's not okay. And if they're not paying you and if they're not making at least arrangement to tell you when they're going to pay you, then absolutely file a claim with the labor board.
Yeah,
you just can't, cannot do that.
Yeah, there's a lot of unknowns and unprecedented things going on right now, and I would hate to see the courtrooms fill up with a lot of these things. So Cecilia's the attorney. I'm not an attorney. My advice is just to have the conversation before you file with the labor board or anything. Just ask the doctor and tell them, this is what I understand to be my rights and getting paid. And then, escalate from there. But, I definitely want people, because a lot of this is just so unprecedented that people don't know like what they should and should not be doing. So it's an interesting time. Right. Again, I'm not the attorney. Cecilia's the attorney. So the next question, Cecilia, is what is the average per diem and percentage paid to an associate? And I would think that varies by location and other variables.
It does. And it varies by the office, and also varies by the experience of the associate, I would say.
Definitely, definitely. And then Cecilia, what if the employer disagrees with the associate and insists that they should be an independent contractor? Who is liable for the fines?
The fines will always it's the practice owner. So it's the employer. It's never the associate. So if the practice owner disagrees and they insist on paying you independent contractor, then that's a risk that they're taking on. And in the event of an audit, then they are going to be responsible for the fines and penalties, not you, the associate.
Perfect. Anonymous is asking, if I can't make rent payments from my office, can the landlord evict me or sue me?
So I believe it depends on the state. So based on what I know of California, landlords cannot evict at this point for non-payment of rent. And frankly, the courts are closed. So how are they going to evict? But I would reach out to the landlord and try to work out a resolution instead of being risked to, getting evicted or, trigger other default provisions under your lease. And so there are lots of potential rights that you might lose when the default is triggered. So it really is important to kind of reach out to the landlord and work out a plan that hopefully can work for both parties about deferring and repaying the rent at a later time, instead of just not pay it and not talk to the landlord at all.
And to say, I have seen some form letters going around that it's a template for what you should say to your landlord when you request that deferment. Do you offer anything like that if they email you the deferment letter or a template to kind of communicate with the landlord?
So no, I don't have a template letter because every lease is different. So I use what I see in that particular lease that's relevant to that case. Sometimes what I'm going to be asking is going to be very different if the practice is located in a shopping center versus a medical building, or if the building is not even open, and or the lease has force majeure provisions, or the lease has hazardous material circumstances provisions, or other. So every case is different, and I write the letter based on that particular case and the lease. So I think it's irresponsible to just use a template letter because it might not be applicable to your particular situation at all. And you might be entitled to better, to more concessions because of what your lease says than just a standard deferment, and vice versa.
Correct. And someone made the statement, did that dentist apply for PPP?
Right.
Right. Maybe you can tell the landlord you have subsidies on the way are coming. As a landlord, I might think, I've heard about all these subsidies. You're a small business. You should have this money. Where is it? So maybe communicating that process to them as well will help to buy some time.
Right. But just not contacting them and to worry about, or feel content about them not being able to evict you, that's not the right solution either. I mean, I'm working with a client that has 4 offices. So there are 4 different leases and 4 different locations. And I'm drafting 4 completely different letters and asking 4 different type of, concessions. And so, like I said, every case is different, and every lease and location, etc., is going to be different.
Definitely. So the next question from Anonymous says, is it legal to file for unemployment despite getting back to work full time if my employer tells me that he or she is not sure if they will have money to pay me biweekly? I do have a valid contract in place with base salary clearly mentioned. Thanks for taking my question.
that's kind of the same question as before. You can't do that. That's fraud. So if you're working at the office, they have to pay you. I don't care if they don't have money, but you cannot apply for unemployment when you are in fact working, because what you're technically doing is fraud and committing perjury, and that could have very serious consequences to your license and other issues. So if the practice says I don't have money to pay you, then okay, I can't work for you. But do not commit fraud by applying for unemployment.
And working. And to say that I think the one important aspect you gave to that is both parties are guilty of the fraud. Is that correct? So this is a pretty serious thing.
Yeah, yeah, absolutely. Because
Let's see.
you got to understand that there are records that can really can be looked at, right? Because when you're applying for unemployment, you are certifying under penalty of perjury that you're not working, and yet there are records that you are working, and there are billing records showing the date of treatment that you are doing, and billing submitted to insurance companies for work that you did. You see, I mean, it's a fraud that can be easily proven. So I wouldn't even consider it for a second.
Yeah, I think the tricky thing, Cecilia, is that gap of time between the first patient being seen and getting back in the practice and doing the PPE training and how we're going to stage the patients in the practice. I mean, not that there's a moral quandary. What you're saying is unequivocally what you should be done. But if we were looking at like, geez, I'm not going to have income, I'm not going to have patients, but I need to get the team in the huddle. So again, when we break that huddle, we're ready to go. So I think that's kind of where the rubber meets the road with that quandary. Cecilia, Anonymous is asking, if an associate is paid as an employee, are they eligible for sick pay? If so, how is that calculated if they are paid a daily rate?
So again, that depends on what the contract says. If the contract says, are you entitled to the benefits under, are you an exempt employee or not? And are you entitled to the benefits offered to all of the employees of the staff? And I believe that if you are classified as an employee, then in California, at the very least, you're entitled to that 3-day sick pay. But as far as what you're specifically entitled to, how, whether you get that at the beginning of the year or accrued over the year, and if it carries over and whatnot, that all depends on how it's addressed in the employee manual.
Perfect. So say, and the next question, is there a legal obligation for employers to provide N95 masks to the staff? Do you know if there's an answer to that yet, or what the requirements are for PPE?
Legal obligation, that's a hard one to answer, because I don't know. Are all the hospitals going to be liable for not providing the PPE for their nurses and their doctors? I don't know. I think there are defensible grounds in the event there is, if a case goes to court, if the employer is taking active steps to try to, order masks and get face shields, that, do whatever, and taking the necessary steps to protect their staff if they're not able to order the N95 masks. But I think in our call 2 weeks ago, the rep from Patterson, I believe, they're saying that they are able to get the N95 masks.
There's understanding a lot of that would be available. A legal obligation, my interpretation, Cecilia, is that we do need to exercise PPE and document that we've gone through or made a reasonable effort or an effort to have PPE in place for our employees. But until there's some dissemination of what's required, I can't see there's a legal obligation, because no one said, the CDA, the ADA, anyone else said that N95s have to be worn by all staff. Do you think your answer to this question will change once the ADA or the CDA dictates what we need to have in place to run the practice?
Yeah, probably. Absolutely. You know, if they're saying that it's a requirement, I mean, I'm following what the hospitals are doing, and I'm interested to see what kind of potential legal liability they're going to have for their, you know, towards their staff, especially in cases where there have been death, you know, of the staff, you know, without the PPE. So I just don't know.
Yeah, it'd be interesting. The employment attorney we had yesterday said, you know, if you make, I don't want to put, it must change the words, but something synonymous with, if you make a good faith effort and you document everything you've done to protect your employees,
Exactly.
it doesn't it doesn't protect you from any litigation or any problems, but it sure helps that you made a lot of efforts and there was some things that were unforeseen that came up.
Exactly.
Is that
like
okay?
It's all about mitigating, you know, what you can provide as mitigating factors, and what you can put up as a defense. And if you do literally nothing, then you know that will open you up for more liability than somebody who at least makes a conscientious effort to get the necessary PPE for their staff.
And Cecilia, as far as unemployment, Anonymous is asking, can a doctor treat emergency patients and still get the unemployment benefits? That's a tough one, isn't it?
Yeah, that one's a little tough. And I believe when you file unemployment claims, there's going to be a question that asks, you know, did you receive any compensation during this time? And you should answer yes, and whatever the compensation resulting from that particular treatment, and you know, which will typically reduce the unemployment benefit, the compensation benefit. So I think you can still apply, so long as you also disclose the fact that, you know, disclose the income that you did receive during that time.
Yeah, and I believe when you're on unemployment, you have to recertify or requalify weekly or every other week, and,
Right.
and then you do go through the same gauntlet of questions where it
Right.
will ask you if you've done any work or had any compensation.
Right.
So a couple more questions, we'll wrap it up. There's a few more piling in. As for a follow-up to my prior question, if I'm entitled to salary and quarterly bonus, can my employer furlough me and forgo paying me my due salary and bonus because he furloughed me for 1 month?
So salary and quarterly bonus, has that been earned, or is that the salary and bonus related to that 1 month that you have not been working? So if it's being earned, without question, you're entitled to that salary and bonus. And if it's during the time that you have been furloughed and not been working, then it becomes a lot more gray, and it will depend on what your contract says.
Perfect. And then Anonymous is asking, my employer is saying that when we do return to reopen, there may not be enough days for me. Will I be able to apply for unemployment as I won't be employed my usual number of hours or days or compensation level? I think that's that same answer we just gave a little while ago, right. Is that unemployment can be supplemental. It doesn't have to be, right. You know, the light switch is on or off. It can be somewhere in between.
Right.
Dr. S is asking, what are the criteria to classify an associate as an exempt employee? And that's that same legal precedent you referenced. Is that correct?
So that's a more tricky question. So for the most part, associates are, you know, dental associates are exempt employees, but there is a huge long list of different factors that you need to look at to see whether that person qualifies as an exempt employee. So you need to understand those, or at least, you know, contact your attorney to make sure that all of those factors are considered and that you have a clear answer on that, that the associate in your particular case is exempt.
Sorry, that person just put in as well, where can I get a list of those factors?
For whether it's so somebody is a exempt employee or not.
Yeah.
You know, contact your attorney and they should be able to tell you. And if you don't have one, feel free to shoot me an email and I'll send you the list.
Perfect. And then 3 more questions. Can an owner set up different employee benefits for an associate than for the rest of the staff as auxiliaries? Can you have tiered benefits or categorized
right.
benefits?
Yeah, a lot of businesses have tiered benefits. Yeah, so that there is nothing illegal about that.
And then Anonymous is asking, when does employees stop unemployment? If they started working but under their normal work hours, for example, they worked only 3 partial days when normally they work for 4. So I think that's that same question that, you know,
exactly.
they're on unemployment and they're going to answer those questions and put in this data that they've mentioned here. And potentially in this situation appears to get 25% of their previous unemployment benefit. And then the question, Cecilia, Dr. L says, the CDC and OSHA are still recommending us to see emergencies only. I know some dentists are seeing a full schedule. Should I continue to postpone treatment or can I start seeing routine treatments?
Well, I mean, I really don't think anyone should go against what the CDC, CDA, and OSHA are recommending. So, because you don't want that extra layer of liability for non-compliance with OSHA. And, you know, the big question is, what are your potential liability to your staff, to your patients? You know, if you are operating your practice in specifically contradicting the current recommendation. So some people are okay with taking on that risk. I personally think it's not worth it. I mean, what I understand is some practices are stretching their definition of what's considered emergency and what's not. But again, I mean, you can do that, but understand that you are taking on potentially huge liability towards your staff, towards your patients, when you are operating your practice in direct contradiction and non-compliance with the CDC, the CDA recommendation and OSHA.
Definitely. And I just got a text from someone with, you know, one of the states, the governor had put the dentist under the labels necessary healthcare providers or something similar or synonymous, which means that they can come back to work or that they're necessary. But, you know, this is the question that keeps coming up is, Jonathan, everyone's opening their offices or saying they're opening them. Should I open them up? And Cecilia, if I was a dentist and I came to you and I said, I have a patient that's coming after me that I had done something wrong or given them COVID, and my date was open prior to what the CDA or the ADA had said, you know, I think that you would have a difficult time. You would defend me, but, you know, our case would not be as strong if, like you said, I opened up contrary to what these authorities are saying. And that's the interesting thing too, is they're not saying you have to close, it's their suggestion. But I think it's one and the same given this situation, that if you did make a mistake, you wouldn't really have a leg to stand on in court, even with the best attorneys like Cecilia. So it's a very difficult time, and hopefully that there's some, you know, authority that says this is unequivocally the time that we're going to reopen these offices. And then I think the important thing too that you mentioned is the definition of an emergency. I don't think there's any emergency hygiene appointments out there or emergency Zoom whitening. It's truly something that needs to be done sooner than later. So Cecilia, we knocked out all the questions in the Q&A, and you allowed me to have a little bit of input and talk a little bit, possibly too much. But I want to throw it back to you. We're going to end this call in the next minute. I want to throw it to you for about 20 seconds for some parting words of wisdom and some encouragement before we close out the call. So go ahead.
Well, thank you again for being here. I hope that the information I shared were helpful. I would love to be a resource to all of you. If there are any questions, feel free to contact me. But again, if I can make one last point, every situation is different. Every practice, every working relationship is different. So make sure that you take the necessary step to protect your practice, your interest as an associate, and do what you can to make sure that first when there are interesting requests made of you, first to think of it from a moral standpoint of view. Does this seem like the morally right thing to do? And then figure out what the legal liability and implication there might be. And you definitely don't want to put your license at risk and commit perjury, can do anything that could really put yourself or your practice in a much, much worse situation than just not having some hours to work or not having some money in the account to pay. So,
perfect.
And my information
Perfect.
is,
go ahead, please.
And feel free to contact me if there are any questions or concerns.
Definitely. So the information is still up on the screen for the people that might be listening to this but not seeing it. www.practiceattorney, practice ATTY, not attorney, but practiceatty.com. And then Cecilia Chen is email address cchen at practiceatty.com, and phone number 855-850-4111. Cecilia, you never cease to amaze me. I know you're an attorney, but your depth of knowledge given to the dental profession and the time that you put into researching these topics, I truly appreciate, and all the people on this call truly appreciate. So, I would definitely, it's a pleasure to work with you both on this, and we do transitions together and a couple other things. So I appreciate your time, Cecilia. I do encourage everyone on this call to reach out to Cecilia if you have any questions or need any assistance. She'd be more than happy to help you out. With that being said, I'm going to go ahead and close out the call, and I just want to tell you guys that I appreciate your time. I appreciate you being here. Hopefully this was a help and add some value to what we're doing as we get ready to go back to work in the office. And, stay safe, stay healthy, enjoy this time with your family. It's going to end before we know it. And that's a good thing and a bad thing at the same time. But that being said, I want to go ahead and end the call. And I appreciate you guys all being here, and we'll see you real soon. Thank you, Cecilia.
Thanks, guys. Thank you, Jonathan, for having me.